Welcome. This is the Domain Name Law Show. We're here every Tuesday, noon Pacific, 3 p.m. Eastern. My name is Todd Ryan. I'm one of your hosts. There's three of us, Jeff Neuman and David Michaels. And I want to say hi to my co-host before we get started. Hey, David, how's everything going with you today?
All right. Things are going well.
Oh, good. Your audio sounds good. Jeff is landed in Boston just, I don't know, 30 minutes ago. So he goes, I'm going to try to jump on. Well, I'm sure he will when he gets situated. We're going to try to get out of here an hour and 15 minutes today because we have, well, a lot to do. And I am going to take Anthony's and David's advice. The only thing where I'm going to mention about the new GTLDs today is this is for the folks listening on replay, or if you're here in the crowd, send me an email to todd@jjnsolutions.com. That is Jeff's law firm. JJN Solutions Law is the legal side of Jeff's business. I say that because Jeff and I also formed an advisory and management company that we call Stage Marks. STAGEMARX. You can go MARKS too. Of course, we got both, but it's like trademarks, but Stage Marks. Basically, just it's important for Jeff to make sure his legal business is separated from his policy, advisory, compliance, management business. So since I got involved with him at JJN Solutions, and helping him structure things, basically, I call myself over at JJN, titles did I give myself? Well, of course, senior paralegal, because I'm handling a lot of that stuff. That's primarily what I'm doing as a paralegal. I just say senior because when I act like fucking more important than just a paralegal, And then I put what else did I put over there? Oh, managing director, which is really an office manager, operations manager. Basically, I'm working with Jeff pretty close on a lot of stuff, pretty much everything, and trying to just move things forward. So if you are applying in the next round, boy, I got to say it's heating up, and we have a lot of excitement going on there. And so if you happen to be, if you're listening to the replay and you happen to be even applying to be a registry service provider, we assist with that as well. So you may want to be a registry service provider and you haven't already got a pre-approval. That window's closed to be evaluated, but it opens again when the GTLD window opens again, which is April 30th. So then you could submit your application to be an RSP if that's your interest. So those listening to replay or those listening right now, we stream live on YouTube. That's what I was doing when I cut out that music because YouTube doesn't want to hear any bullshit. So you can hear replays on X, YouTube, and live, of course, on both of those. And then Spotify and Apple I do afterwards. But okay, so that's what I wanted to say there. Or, I was going to say, if you have a legal issue, I just posted, you guys know Bill Hartzer, who helps people when their names are stolen. Well, I just saw a post of his. I was trying to read it, but I had to get ready for this show. I was going to read it in full here in a minute, maybe while I'm talking even. But I posted there, hey, Bill, you provide a great service. We've all known that he helps people when they have their names stolen or something fishy going on with their names. I said, hey, if you have any legal issues, your clients may want to file a lawsuit or may need some legal help, or they need it or want it. Anyway, have them reach out to JJN Solutions and or turning it up. But anyway, so definitely domain disputes and domain name legal issues. But also, we have a couple, we have clients that are, say, cinematographer. So we're doing some management. That's more on the Stage Mark side. But my point is, if you have any needs with regards to advisory management, big fucking advertisement today, huh? I'm like one of those housewives. I don't make any money on this show, but I promote my ship. All right. Well, I think he's going to be joining us, David. But okay, so I wanted to get to some of our news and that thing that we talked about last week, Arif, That was the new registry agreement. The only thing I was going to talk about that was it in fact meaning they need to have renewal rates uniform across all their domains? That we're talking about if a registry, the new policy is you need to have consistent, uniform renewal rates. And it doesn't mention specifically in the agreement if you have different tiers and a person registers a domain at a $500 tier and is aware of it at the time of registration, does that mean that that tier can remain, those names in that tier can remain at a $500 renewal rate? It's just not clear. That would make sense, but yet it's not clear. So that was something I was going to ask Jeff. It seems like it says ask lawyers in the space. All right. But anyway, so that was that. If you want to check out our outline, I say please do. That's why I put it together. It's at dnlshow.com/outline. The second B2 on the outline is orcid.com. Owner files ACPA lawsuit to overturn their UDRP. So last week, I believe it was, we did the orcid.com domain dispute, where the registrant, the domain owner, lost the name in the UDRP and immediately filed an ACPA case to freeze the thing. David, I looked into this lawsuit a little bit, and as I mentioned, I talked with this domain owner, this domain investor at Mira Holdings that we all have heard about. You know, he's part of a lot of UDRPs because he has a lot of great domain names. What do you know about this case, Dave? This lawsuit that Mira Holdings has filed to freeze or to stay this transfer.
Yeah, so Mira Holdings filed a lawsuit in Colorado, the District Court of Colorado, and James Jew is representing him from the Thomas firm. And James Jew, sorry, Joe, Juo is how you spell his last name. Um, he he's an hourly lawyer. He did a case before that he won on the issue of priority dates. So even if Mira Holdings is not the original registrant of this domain name, they still get to retain the registration date of 2001 as their priority date for purposes of the ACPA in Colorado. And that's the main claim, declaratory judgment that they have entitlement to have the name. And there's also a claim in there for tortious interference with the contract with the registrar. So that's interesting. That's not a standard thing that I see in the Arizona complaints. So, there's benefits to filing cases in Colorado. But unless you have like a couple $100,000, taking a case like this to trial is a long haul. But I think this case will settle on summary judgment because the judge will just say, hey, look, the priority date predates your trademark by 10 years, you got no case. Um, you know, unless you're asking for damages, it'll just settle right there.
I hope you're right that the domain owner wins in this case. Jeff Neuman, our own Jeff Neuman, he referred the Mira Holdings over to the two gentlemen, James and Scott, who over this Howard law firm in Colorado. Because Mira reached out to Jeff and was like, hey, and Jeff was like, since you have it at Name Bright and you're going to, like David just mentioned, he was interested in this other action, tortious interference with the contract. The thing is basically this company, ORCID, who when you do search them, they do come up on page 1, 2, 3. Basically, they're like the only company that goes by this name. We know it's sort of a misspelling of orchid, but since they're prominent, that is why they won the UDRP, because the panelists felt that you search this, you're a domain investor, you're a pro, you search this, you should know that this company exists. Let's get Jeff up here. And they ruled in favor of the complainant. They gave the domain, and now this gentleman's, filed their filed the federal ACPA action. Let's check Jeff's audio. Hey, Jeff, how's everything in Boston?
I am here. I'm walking on the streets, going to my hotel, but didn't want to miss you guys. So I'm here.
Well, great, and thanks for doing this. And I was going to say, chime in when when you feel appropriate. I might say, "Hey, Jeff, what do you think?" And you can say, "I'm getting mugged." No, anyway, that's Boston, so it seems like it's pretty safe there. Where do you stay, by the way? Downtown?
Yeah, I'm staying just across from where my meetings are this week. So, yep, just actually by the wharf, I think.
Yeah, the best thing they've ever had there is Larry Bird, and that's from Indiana. All right, well, that's exciting, Jeff.
I
You
hear
know,
they got good chowder though.
yeah, oh, yeah, the chowder's good, and then of course the Tea Party was pretty cool. Um, All right. Well, we were talking quickly about. Oh, well, now that you're here, Jeff, I can ask you. So I was last week mentioning this new registry agreement, and I've looked at it pretty closely, but still couldn't figure out. There was one thing that I thought was important to domain investors because that registry agreement is mostly obviously for registries, and there was one part of it that said renewal rates need to be uniform across all domains. Does that mean all domains in a specific tier, or is a registry now going to have all their domains at the registry renewed at the same rate?
It's per tier. It's not worded the best. Um, but we tried to get ICANN to change the wording a little bit, but it was afraid to do so, fearing that there'd be so many comments. But the way it's enforced is, yeah, if you put it in a tier, then, and you raise prices for that tier, as long as everything in that tier gets raised or lowered or whatever it is, that's fine. They just don't want ad hoc treatment of domains where, you know, one day it's X dollars and then, the next day it's twice that. So it's really just to kind of avoid those ad hoc increases.
Yes, and it's clear on the specials. I mean, like if you have a discount special going, you need to be clear on that. But thanks for clarifying that, Jeff. Last week when I read it, I was like, it's not clear. Arif then brought up, hey, they probably allow the tiers to stay at their, individual rates. And I thought, Arif's right, it makes sense. And then I went through it again, that whole section, and it just doesn't say specifically. And then it says ask a lawyer in the space. I thought, I know a guy. So fantastic. Ask you, and you clarified it exactly like we wanted. Arif was on top of it. He sort of knew, and then but no, thanks for clarifying that. Anyway, just so we know going forward, basically, if you register a name and it's a $500 renewal and they're clear about that, they do have to be clear, then it's okay for them to obviously have that $500 renewal come renewal time, even if they have other domains and other tiers at
Well,
lower
they
or higher.
they can raise the rates, right? But they have to give at least 6 months notice to raise a renewal rate. So it's not like they can't raise it, raise the tier when you sign an agreement, but the agreement should say something to the effect of we have the right to raise the entire tier, something like that. But yeah, they do have to give you notice that it's subject to increase, but they have to give you 6 months notice. Well, let me take that back. They have to give the registrar 6 months notice. Whether the registrar chooses to pass that on or not, that's a whole other issue we've talked about here before.
Yeah, and if anyone wants to see that new registry agreement, I mean, there are some interesting things for domain investors to think, okay, so that's what the registry is obligated to abide by, adhere to these rules. And you can, some of it, like I said, some of it is interesting. Long document, some of it is interesting. Yeah, you can see the link at dnlshow.com/outline. And by the way, there after then we were just discussing this ORCID case where we know the registrant lost the domain in a UDRP and then filed a ACPA case. Jeff, David brought up that this. Okay, so we knew, I was mentioning that you referred this gentleman to these attorneys in Colorado, because that's where Namebright is, and we knew that he had planned on he did file this torturous interference with the contract in addition to the declaratory relief that he's asking. Have you seen this before, where a company says, "Hey, I have an agreement with this registrar, Namebright," and then this company, this complainant in the, now it's a defendant, but complainant in the UDRP made these false statements, so I want to get some money for these false statements. Basically, this interference with the contract. Have you run into that before?
Well, I've certainly run into people making that complaint or people making that allegation. It's difficult. It really is, especially with the, UDRP that they won. But yeah, I mean, I suppose if you could show that they made that statement, a knowingly false statement or multiple knowingly false statements, it's again, it's hard because you have to show the contract that you interfered with, or that um, the defendant knew you had a contract and knew that you were interfering with it. I've seen the allegation. It's a tough one to win. So it's one to watch.
Yeah, thanks for that. Well, I know you'll be checking in shortly, so if you need to take a break from us. So I'm going to go to this next story before we get to our cases. And the story really is a case. It's Lambo.ai. And we all know, well, if you don't remember, Lambo.com was lost in the UDRP. The domain owner tried to keep it, filed a federal case, lost it, I guess appealed it. The appeal was upheld, and then he tried to want it to go to the Supreme Court. They said, we're not hearing this. We're going to go with the lower court's ruling. All right, so that was Lambo.com. This is Lambo.ai. So Lamborghini files a UDRP against Lambo.ai. Well, it seemed like a real easy case for the panelist. He's like, of course that's a transfer. You can't do this or that or that. To me, I just think there's defenses in this case. And a couple of things I want to ask you, David. So I thought they had a copyright for Lambo, or I'm sorry, a trademark for Lambo, and then they let it lapse. That's one question. Was that I guess they have some EU trademarks for Lambo. We know they do for Lamborghini, but apparently they do for Lambo. And also, David, so do they have an active trademark for Lambo? And what defense could there have been to protect this name?
Okay, so first of all, Lambo is a brandable term. There are a lot of companies that use a noun plus a O at the end. For example, Vendo, Cardo. Vendo is like a company that helps market your online business. Cardo is like a motorcycle helmet style audio system, so you can listen and speak on the phone. But those are, I have those versions in .cas, but there's a lot of companies that go with O at the end, and it's like an Italian variation of a word ending in O. But if this particular registrant was planning on building an AI startup, 2022 was too early to build any AI startups, so it's understandable that it's not built out yet. But if he had a track record of doing that, now he does live in the San Francisco area. He is a tech entrepreneur, but you know what? He's focused on speed bikes, racing bikes. And his father was some sort of champion cyclist in Europe over previously. So, and actually his dad had an ACPA case over his own personal name. So that was interesting. But Gregory lost this case because there was an allegation that an email was sent from his email address to Lamborghini offering the domain name. It didn't say a price. It didn't have a name as to who was sending the email. Was that email bona fide? Did he actually send it? He didn't respond to the UDRP complaint. Did he even receive it? I don't know. Did he notice it? If he saw it, did he think it was real? Because who knows what the Czech forum is? Most people never heard of it. Okay, maybe I've heard of WIPO. The ADR forum in the US is more popular now, but the Czech arbitration panel, like who has ever heard of that? So there's a good chance that he just ignored it or didn't see it. Now, if he were to file an ACPA case in California, and claim, hey, I didn't send that email to Lamborghini, and I was planning on building an AI startup. I live in San Francisco. He has a small chance of winning. And the problem is because the Lambo.com case made a problem. So Lambo as a trademark was canceled in 2017 in the United States because Lamborghini stopped using it. They didn't send in a specimen of use as they were required to. And so a year later, it was automatically canceled. So they claimed in the Lambo.com case that, hey, we still have common law rights in it, even though we're not using it. And the lawyer representing Lambo.com said, yeah, people know about that. And I think it's a subtle acknowledgement that maybe was misguided, but that caused a problem. So even on the appeal to the Ninth Circuit, there was no way to win that case based upon that admission and the motion at the district court. So the case was lost. What do you think, Jeff?
Jeff, is it a case just
Did I
of
cover it all,
Lambo
or?
being so popular? That's different than what David said, Cardo and Vendo. Lambo is just so popular as people relate it to Lamborghini that was what won this for him, that Lambo.ai, UDRP.
Yeah, I mean, I think there is something to be made of that. Um, Certainly, the fame of a mark always comes into play when there's a UDRP. But I mean, that Lambo.com case was a real tough one, um, and we all kind of knew that from the beginning when we saw the posts on, oh, what was that, name pros, right? Um, it's tough, and yes, the more well known a mark is, the harder it is to overcome that with a nickname or whatever other kind of excuse you want to offer. It's a tough one to win.
Yeah, we saw that with this HCL case, HCL.ai, that the panelists claimed that the mark was so famous, and then we see that with there was another case on the tip of my tongue that was just recent, but basically, the ORCID case. That's why the panelists there said, "Listen, you're a professional. If you're a domain investor, you can't help but search and see this company." So they're so prevalent in searches. Sometimes it may not even be popular, but now they're expecting you to, especially if you're a domain investor, to search and to do some research on that name. I'll say if you buy a domain at auction, well, they automatically assume, well, you know what's going on. That's how I look at it. They assume, well, you know what's going on if you know how to work an expired domain auction. So you're savvy enough that you should be able to, like the gentleman in ORCID, before you buy it at auction, you should look and see ORCID.com. Geez, that company would be the perfect fit for it. That's like the most, like I said, prominent one, the only one I can find. There may be other people that use that thing, but you think if I wanted to use that name as ORCID and I wanted to start a nursery in my little town of Wichita or wherever, you should have the right to do that. Of course, in the UDRP, you need to show, here's what preparations I've made to use this as my nursery, and I want to be, I mean, you got to, it's just ridiculous, I say that because Disney wants to make a movie about something. It takes him a decade to get going on it. But yet, when you're, and this is the UDRP, when you're claiming that you're using a name that may include somebody else's trademark for some other reason in another class, they're like, well, what have you done, bud? What, do you have a business plan? And then have you spent any money? And it better be more than just an idea, and even really more than just a one little PDF anyway. So it is, when there's famous mark, there's a famous mark, whether you know it or not, included in your domain name, you're really at risk with these UDRPs. And yeah, you can say I didn't even know about them, but sometimes they just simply don't believe you. Okay, we're going to get to our first case. So Lambo.ai went the same route as Lambo.com. Lamborghini got it. Okay. Our first case today. Okay, these first two, I don't know, they upset me as a domain investor. The first case, LosAngelesFitnessTrainer.com. This is unbelievable. You know how many fitness trainers are in Los Angeles? I mean, I can't more than well, I was gonna say more than lawyers, but it's a fucking that can't be, but probably pretty close. But more than that, it's like lawyers, actors, fitness trainers in LA. Okay, Los Angeles Fitness Trainer.com is the domain name. It was registered this time last year, June 6th of 2025. The guy's over in Nigeria, but he registers a name, Los Angeles Fitness Trainer, thinking, do you know how many fitness trainers are in Los Angeles? And this is a 4-word, if you want to count the city, 2 word. LA Fitness decides to go after this guy, and LA Fitness says, we have a trademark, LA Fitness, since 2000. We're super popular. Even people outside of LA know of LA Fitness. And I think they have stuff nationally. Who knows? I don't know. And but they're big and they do a lot of advertising. Been around for 25 years. They said L.A., obviously Los Angeles. So this guy having our mark in his name, because Los Angeles is the same as L.A. to them, and then it has fitness in it, and then he just added trainer, which of course goes with the word fitness. So the anyway, the panelists said, it makes sense to me. So check box 1. Yes, you do. You do succeed at the first element here, that the domain does include your mark. LA Fitness is your mark. Okay, there's a lot more to it. David, I'm going to ask you about they end up ruling that this respondent had no rights or legitimate interests. Why would they? I mean, would a domain owner of the domain Los Angeles Fitness Trainer have rights or legitimate interest? Do you feel? Give us your comments on this case.
Yeah, first of all, this is one of those rare cases where I actually would challenge the first part. I would say that Los Angeles Fitness is not confusingly similar under the UDRP policy with LA Fitness. And the reason is because you cannot register Los Angeles Fitness as a trademark. You can't register Los Angeles Athletics. You can't register Las Vegas Athletics or the Oakland Athletics as a trademark. You cannot claim that ownership of the name if it's purely generic, geographically generic. And those are real cases that have happened in the past. So if it was a real fitness trainer in Los Angeles with this name, he would have a legitimate interest in this name. Can you register a 4-word name like this that's purely descriptive and offer it for sale to fitness trainers in Los Angeles? Sure, there's plenty of precedent for that. The problem is this name has been registered multiple times over the last 20 some years. And you know what? It was never sold. So the thing I found really funny in this case was it was only listed for $650, and yet um, Sislo and Thomas decided to file a UDRP complaint to waste their client's money instead of just paying the $650. Like the UDRP complaint filing fee is $1,500, so why bother? But I think that this decision was wrong. Neil Anthony Brown should have understood that Los Angeles Fitness is geographically descriptive and not registrable, and therefore not the same as LA Fitness.
Jeff, I mean, it is weird. We know this panelist seemed to be, I don't know, he's, pretty savvy, very experienced. But I agree with David about the first prong. Yeah, Los Angeles Fitness is different than LA Fitness, and he's right. It is geographic, but why do you think? And the guy didn't reach out. He didn't reach out and say, "I want to sell this to you for $650." The complaint sort of act like they did. They were offering it for more than the price they paid, which was registration fee. They were trying to either sell it to us or to a competitor, which is not the case. They're just saying that. There's no proof of it. Why do you think Neil Brown ruled this way?
So he's from Australia, isn't he? If I remember correctly. And I don't know if the rules there are different with geographic marks, or whether it's a case of someone here. I'm wondering what if someone here had registered something like Melbourne Fitness, um, whether that would be seen, whether the U.S. attorneys would see that as geographically descriptive. probably, hopefully. Um, I don't know. I mean, it's an odd one, right? Because when I first read it, they said that I got the misimpression of copy because he used the word copying, and I thought he meant copying like the website or things like that. No, he just meant copying the domain name, which was an odd choice of words in a decision. So I don't honestly, I don't know. It doesn't. I agree with you guys. It doesn't make the most amount of sense. But the only thing I could kind of attribute it to is maybe where he lives. I don't know.
Yeah, Jeff, you're right. He mentioned, really, I think it was the complainant that mentioned this domain owner is copying and plagiarizing our trademark. And what they meant by that is basically just using it in their domain name. And the panelists bought it. There wasn't plagiarizing on the website or anything like that. Anyway, so this domain name, LosAngelesFitnessTrainer.com, a lot of us have Los Angeles chiropractor, Los Angeles whatever. I have LA Dancer, I believe, something like that. But I do have Las Vegas Dance School. Now you make me think. I think I still have it. I don't know. Or Dance Studio, something like that. It makes me think, David, that maybe I got rid of it, but that you can't really copyright something like that. So descriptive, just geographic and descriptive. Okay, so this one seems
By the
like,
way, it
you know,
has Afternic name servers, so it's definitely just a GoDaddy landing page. There's no copying of anything.
yeah,
Yeah, and I don't
650
think
bucks.
Neil. I actually don't think Neil is an IP attorney by trade. So yeah, it's an. I mean, I agree with you guys. This is not a case that I think should have come out this way. But we'd have to ask Neil, I guess, and I haven't talked to him in a long time.
Yeah, and there's something like I said. We see the summaries, and some of these summaries, I think it was it the next one, but some of these summaries are so thin. It basically just says, you know, the complainant says that the name has their mark in it, and the person has no rights to it because they're not known by this, and then third, they registered it targeting us, the complainant. And then there's like no response, and then the findings. And you're like, all right, well, what was really in the complaint? Then you look at the findings, the decision, and you think maybe the panelist, when writing this summary, is going to let us know that there was something that we're missing, so that we could be. But in some of these summaries, no, it looks like nothing missing. But anyway, so that gets transferred. Los Angeles Fitness Trainer.com ordered transferred, and so we'll go on to the next case, which I'm going to give away because I want to. Babybookpublishing.com transferred away too. Baby book publishing, that's like book publishing to me. So children's book publishing, I would say that's pretty generic. Baby book publishing seems very generic to me. But anyway, this DIY Media Group is the complainant. They're going after Lulu Publishing. I take this personal. I call my wife Lulu sometimes. Hey, Lulu. Oh, she's at the horse right now. Okay, so DIY Media Group is the complainant. Lulu Publishing. I think they're both out of Texas, or one's out of Texas. I know that Lulu is. Um, but the complainant in this case says we got a product called Book Baby. Okay, it's called Book Baby. It's not Book Baby Publishing, but they have a trademark for Book Baby. All right, so that even makes me think. All right, so you got a trademark for Book Baby. That's different than That reminds me. I'm going to go off track here real fast. Float Baby was on the Shark Tank, Float Baby, and their domain was floatbabies.com. And I was watching Shark Tank and I thought, I'm going to check. I checked Float Baby, it's available, and that's the product. It's all over the product, Float Baby, but yet they're on Float Babies. So I register Float Baby, and I just price it. I didn't target them, of course. I just price it, and it gets sold about 6 months later to them. Okay, so that's nice to say. Babybookpublishing.com is the domain here. So this company has a trademark for Book Baby, and they say Baby Book is just the reverse of our trademark. So it's really confusing. They've added the word publishing. We are a publisher, we're one of these do-it-yourself publishers. And this is so obviously this is confusing to our mark. And that's why we filed this. The I don't know why I don't have the panelist here. David, do you have who the panelist was in this case? I could see it real fast, but I don't know. I have this written down in big letters.
It's Sandra
Oh,
Franklin.
yeah. Thanks, Jeff. You're right. I remember that. And then in the next one's David, somebody, famous in the UDRP business, does a lot of Okay, so Sandra said, yeah, that's baby book publishing. That's confusing to book baby, and you're a publisher. So yes, let's go to the next, the next step. And the respondent, keep in mind, did not file a response here. So the panelists went with what was submitted, and they said the respondent has no rights or legitimate interest because they're not commonly known by this domain name. They looked up the who is and saw Lulu Publishing, so they just felt that, obviously not known by baby book publishing. And then the complainant said, they're certainly not authorized to use book baby, which they're not using book baby. So when words are reversed, it to me, most of the time it's a completely different thing. It's, most of the time it's a completely different thing. That's in my opinion. Now, sometimes it's obvious if it's Queen Dairy, okay? But anyway, the respondent used the domain name offering competing publishing services, and that's what really got the complainant upset. And they said, just like in the last case, Jeff, this complainant sort of alluded, well, they're sending out, they're soliciting customers and payments, and they're impersonating us via email, which I don't know what evidence there was. They said it, but of course this customer's offering publishing services too, and says, to their customers, we're soliciting for business. We're telling you how you can make payment to us. But the complainant goes that extra step and says they're impersonating via email. I don't see the evidence. It's not mentioned what evidence is there. And then get to the bad faith registration. Well, Jeff, I'll throw this to you. I don't know if you recall anything about they said that, that they brought up again in the bad faith that there was used to impersonate complainant, and emails show respondents' knowledge of book baby mark. Okay. But anyway, so what do you recall of this case? I don't expect you to have,
Well, I didn't get a chance to see what was on the domain, because the only thing I see when I read it was a Cloudflare page or something. And I don't know, David, did you see what content was on there before that? Because I didn't see anything that they were offering. I don't know if I don't know what happened, but David, did you notice what content was on there?
When I looked on archive, there was no history on this domain name. It was only registered last year. So there's nothing I can see. But, Lulu is a big company. They're on lulu.com. And they are also a self-publisher. So basically, if you sign up at lulu.com, you can publish your own books. And baby books are a huge category. So I think book baby and baby book are totally different. And I feel like this is just a prelude to the next UDRP for babybook.com. And if Sandra Franklin is the UDRP panelist on that one, she'd order a transfer too. Isn't that insane? So
Yeah. And I think the other strange thing is, if the mark was or if it was baby book, the USPTO would have never registered it, right? Or any patent and trademark office that does a substantive review. So,
exactly.
so the fact that they're saying so it can't be confusing, because otherwise, if it were confusing, the USPTO would have said, no, we can't register that mark. And they must have overcome that descriptiveness, genericness in their USPTO filing. Again, I haven't looked at it, but that's certainly something I would have looked at if I were representing the respondent. Of course, the respondent doesn't do themselves any favor by not responding, but yeah, this is another one that's a head scratcher.
In the previous case, I can understand, like David mentioned, you see a Czech arbitration forum or whatever, you're thinking, could this be spam? I mean, you're not really sure. This case was, was that a WIPO dispute? Must be. My notes are, I used to be so inclusive, so detailed.
This was a forum
Forum.
forum decision.
Ooh, could have been Jeff. Yeah, for those who don't know, listen on replay. Jeff is not only an attorney, he's a UDRP panelist at the forum. And then, of course, when they have that WIPO has a 3-member panel, he can always be there. Hey, Jeff, if somebody doesn't file an ACPA case to stay this transfer within the 10 days, that, okay, so it doesn't stop the transfer, sort of freeze the transfer, but they can certainly file, like Lulu, could certainly file an ACPA case to try to retrieve the name back, correct? I mean, they still have recourse. I didn't know they were such a big company, David. I mean, I wasn't paying attention. So they're on lulu.com. Why wouldn't they have responded? And this is certainly one that I feel like they have rights to. Lucky they didn't have a whole division set up, baby book publishing and something on the website, but might have helped them. But what happens when it's past the 10 days? You still have the same rights to file an ACPA, but just the domain's already been transferred, right?
Yeah. Yeah. I mean, that's in most cases, there's, obviously the domain will stop resolving to your, to whatever site you had it pointed at when you lose it. But, and that's always bad. But yeah, under the ACPA, you can absolutely challenge it afterwards. Um, unless you have the unlucky, you know, uh, fortune that France.com had, which was that, after the name was transferred, then the country of France decided to join in, and then you couldn't challenge it under the ACPA because of sovereign immunity. But in general, that doesn't happen. So in general, yes, you can challenge it after the transfer.
In these time frames in lawsuits or something, basically 10 days to file. And sure, it can be done quickly if you have, a lawyer at your disposal. And if not, you reach out and you try to find one. It's like we saw the guy in the ORCID case. He's like, I don't want this name to be transferred away from me. I want to have a court rule that the domain should stay with me. But you have to be on it, and if you're not, as Jeff just mentioned.
Well, and it's 10,
Yeah,
it's 10 business days too. So it's a little bit longer.
yeah, and the cost. I mean, it's really the attorney's cost of putting together the complaint. But what is a rate? Is it about $450 to file in federal court one of these things, or what is it? Do you recall?
I think it depends on the jurisdiction, but yeah, 450 I know is Eastern District of Virginia.
Yeah, that's what it costs to have a couple of lobster rolls out here. Okay, so we have our final case for today. So those two were transfers. Domain investors, if we had something like that, Los Angeles fitness trainer, I don't know, it's so long, but still, that's like I said, actors and lawyers. There's hardly anything more than and in LA than fitness trainers. But that and baby book publishing, this is right up domain investors. Some, it's like this is their niche. Okay, quiche, niche like quiche. Okay, our final case today is because I'm a big fan of his, so I brought it up. No, I don't know Kenny Chesney music, but I do like the guy. I don't know why. He seemed like a nice guy to me, Kenny Chesney, I think. Better than a couple of these other country artists. I don't care too much. Okay, so the domain name in the third case is kennychesney.shop and kennychesney.store. And before I tell you, this was a case, it was against Kenny Chesney. I think, man, he was the complainant, and he filed it against, I can't pronounce the name, last name Fan Hong. They're Asian registrants. Yeah, they are out of Vietnam. And David, I wanted to ask you, so this case, tell us about the facts of the case and then the decision, if there's anything to do with these names that's really within the bounds, basically not infringing. Is there fair use possibilities with these things?
Sure. So I had to look up who Kenny Chesney was. I never heard of him. Um, according to Google Trends, his popularity dropped off dramatically since 2005. Yet, according to SpyFu, he still gets 40,000. His website ranks for 40,000 SEO searches per month. I think he gets 6,600 clicks out of that. And sorry, Kenny Chesney is on kennychesney.com. But these other sites, these parasitic sites, this one in particular is kennychesney.shop, there's a .store. They were getting less than 30 visits per month. So it's not a lot, but it's a little bit of parasitic site. One of them had a really nice, well, decent WordPress site where you can buy merch with his name and photo on it, T-shirts, cups, hats, all that kind of stuff. Now, Kenny Chesney actually got a trademark registration in 1994. They didn't mention that in the complaint, but he has a registration. He was signed by a big label in 1995, and there's not much you can do with this thing unless you are going to one of his concerts and you really hated it and you want to set up a great gripe site. I don't like going to see Kenny Chesney in Las Vegas at the Sphere. It just doesn't sound right. You know, if you want to do a gripe site, go ahead. But other than that, you have no right to use his name. He has rights under Tennessee law, the Elvis Act, under the Lanham Act. You're going to be sued and you're not going to win. And you're likely going to lose more than just a domain name if you're in the United States. It's just not worth competing with this type of thing. Any type of star, just like stay away from their names unless you really have a problem with one of
Yeah,
them, and
well,
it's legitimate.
and even then, like a .store, .shop, that's where the TLD kind of matters, right? And if you're going to have a .store, .shop, that at least implies, you're using it for commercial activity. So even a gripe site, I don't think is possible on a .store, .shop. If you want a .com, .xyz, something that doesn't have a commercial connotation, fine, but not with the .store, .shop.
So could someone do kennychesneynews.com, for example?
Be
For
really difficult.
commentary?
It'd be
Yeah.
really, really difficult to do that. Um, it would have to purely be news, no sales of advertising, no commercial transactions on it. I mean, in theory, yes, but very difficult to do that.
And a guy like me, it's super narrow, like Jeff is saying. So I'm always thinking, is there a way? And sure, if someone said, I only buy used concert shirts solely, Kenny Chesney, I have a shot. It's just, you'd have to have lawyers. You'd have to really have proof that, and you're trying to argue fair use. It's just really almost not going to work. And then there's also the issues like David was mentioning, the hee-haw law. I'm sorry, Tennessee law or whatever. It's like these California laws, name and likeness. So sometimes you can get away with some type of, I'm just making this stuff up, federal fair use, but yet there's still some state, name and likeness issues that you could run into. But it's just so narrow. It's like, what are you doing here? But could somebody, like BruceSpringsteen.com is owned by a fan, has always been. But Jeff mentioned it. If you're going to do a fan site, a news site, really needs to be non-commercial. As soon as you sell an ad on there, then you're running into those issues of, okay, you're selling an ad and in some cases you can't actually do that, but then you can be scrutinized. You better be ready to defend yourself, because now that you've made it commercial, they're going to bring in all the different laws against you, not just this fair use law, but like I said, are you making money off somebody else's name and likeness, off of their mark? I mean, so on. It just, you really need to, I don't know, have a, if you are going to do something like that, have the disclaimers, have your lawyers, have your defense ready, and answer a complaint and say, here's why, legally you believe you have rights to. That's commercial. We know that. But anyway, so kennychesney.store was transferred. kennychesney.shop was transferred. And David, you want to know whose popularity really peaked in 2005? Yours truly. Oh man, since then it's just been I was something back then. Woo! These people knew me. All right, so listen, we appreciate everybody being here. This is one of our shortest shows. It's fantastic. It's like everybody getting out of class early. Really, thank you for being here. Next week, when I say big show, don't know the cases yet. Don't know what we're going to talk about. I'm assuming it's big. That's going to be Tuesday, noon Pacific, 3 p.m. Eastern. Yeah, definitely show up this Thursday on the DNX show. Even if I don't know if I want to be able to host this Thursday, but Josh will be there. So that's the Pure Domain Investing Show, dnxshow.com. You can see what's going on there. And that's 10 a.m. Pacific, 1 p.m. Eastern, right here on X. Thanks, everybody, for being here. Enjoy your day wherever you're at. Take care of yourself. See you soon.